All right, last week we had a wonderful Supreme Court decision, but idiots like me are confused. Was it a decision that stopped these ridiculous nationwide injunctions by these judges? Did it end birthright citizenship? I've seen headline after headline, and they're all saying different things, and I don't know what's going on. So obviously we need to bring in the great professor, Bill Jacobson, Cornell University law professor, and of course, founder of Legal Insurrection. Okay, Bill, what was this? Are we done with birthright citizenship?
No, we're not even close to done. We are done with
Okay.
a narrow set of relief that the district courts have been imposing on the country called universal injunctions, where a single federal district judge binds the entire country and everybody in it to a ruling, even though those people are not part of the court case. That's what's plagued Trump 1.0 administration and Trump 2.0 administration, because there are over 650 federal judges. And Trump needs to win every single time because any one of those judges could terminate a program of his or an action of his, whereas the challengers only need to win once. They only need to win one case. So the Supreme Court said that the federal district courts do not have the authority, except in rare circumstances, to issue these universal injunctions. But as you can guess, there's a big but about that.
Yeah, that's you know what, you got me right away, Bill, when I heard you say narrow. Why don't you go ahead and just explain what that means?
Sure. So, what the court said is that as a general matter, the federal district courts, which are created by Congress, most people don't realize this. The federal district courts are created by Congress, not the Constitution. The Constitution only creates the Supreme Court, and therefore the federal district courts can only do what Congress has given them jurisdiction to do, notwithstanding federal judges thinking they are all powerful. In fact, they are hemmed in by federal legislation. And that federal legislation, the Supreme Court held, does not permit federal district court judges to issue these broad injunctions, except they can fashion those if it's absolutely necessary to afford somebody what they called complete relief, meaning if there's no other alternative to it. Or they could use other procedural mechanisms, which is what I expect to see, and we're already seeing, which is class actions. So class action lawsuits are lawsuits brought on behalf of a group of people by a representative plaintiff, and they can bind hundreds of thousands or millions of plaintiffs who have a very common issue, and they can bind the entire class of people. So there is a big loophole. This is a big deal, the fact that the judges now have to think of alternative ways of going there, but nobody should think that this ends it. And in fact, the case that was before the Supreme Court about the birthright citizenship executive order has already been refiled as a class action. So big win for Trump, will affect a lot of cases against him, but it's not a perfect remedy. It doesn't shut the door completely. It shuts it most of the way.
Okay, so it's not a silver bullet that got us all the way through, but I mean, does this mean we're going to see a fraction as many of these as we saw before? Half as many? Handicap it for us.
Yeah, I think it's going to be half as many. I think that most of the judges will have to
Okay.
go through this
Well,
analysis that the Supreme Court has given. So it will stop a lot of the abusive injunctions, but it's not going to stop all of them. And it will simply make the plaintiffs and the more activist federal judges more conniving in how they frame things. But it also should embolden appeals courts that will maybe put an end to it. So the best I can say is it's a very positive development. Trump administration was right to celebrate it, but nobody should think that the lawfare project that the Democrats have embarked on to stymie the administration through dozens and hundreds of lawsuits, that's going to stop anytime soon.
all right. All right. Now let's talk about the ruling itself, because somebody who surprised everybody was Amy Coney Barrett, not necessarily for how she voted. She can be here or there with that, but for how she just, in the most professional way possible, just whipped Ketanji Brown Jackson. What do you make of this?
Yeah, I mean, I've heard it described many different ways, and I've described it different ways. But, she took KBJ out to the woodshed and beat her legally pretty
Uh-huh.
sound. I mean, they
Mm-hmm.
didn't call her stupid. They didn't call her incompetent. They didn't call her, ignorant, but they came pretty close. They called her those things without using those words. They basically said, we're going to ignore everything she's saying in her dissenting opinion because it's contrary to 200 years of constitutional law and contrary to the Constitution itself. And what Ketanji Brown Jackson said was, notwithstanding the legalese of the statutes, she used the term legalese, and the majority mocked her for that. Notwithstanding the legalese, which of course is exactly what judges are supposed to pay attention to, notwithstanding the legalese, we should do what we think is right. And it's a very activist, very critical legal theory, very social justice warrior approach to things, which is if a judge sees a problem she doesn't like, the judge should solve the problem and should not get bogged down in all these things like limited jurisdiction. And in fact, the one of the most famous lines, there were many of them from the majority decision, was that Ketanji Brown Jackson decries the imperial executive, but in fact wants an imperial judiciary. She wants a judiciary which can do whatever they want. And that's just not the way it's set up. That's not the constitutional structure. It's not the legislative structure. It's not the way things have been treated for 200 years. And this is really what you see when you get a total social justice warrior on the court. You get dispensing with our constitutional traditions and our constitutional protections, and somebody who does whatever they want. And so it was a really brutal, there was just some great lines in there to quote and mock Ketanji Brown Jackson. I keep wanting to say Jackson Brown because I grew up listening to Jackson Brown. Ketanji Brown Jackson, it was an embarrassment. But what's important is one, it was an Amy Coney Barrett decision. She's not known as a hothead on the bench, okay? If this thing was written by Alito, you could certainly understand it. But this was by somebody who's viewed as very polite and very proper on the court. She wrote it, and 6 judges joined in it. Remember, any of those judges could have said, hey, I don't think this is appropriate for the majority decision. You want to bash her, go do it in a concurring opinion, in your own separate opinion. They all signed on to it. The 6 justices signed on to this bashing of Ketanji Brown Jackson. And importantly, her dissent was not joined by any other justice. Not even Sotomayor nor Kagan were willing to put their name on what Brown Jackson had written. That's how bad it was. And so she's a laughing stock, frankly, after this majority decision. And it doesn't matter to her, I'm sure, because she's got life tenure. She'll be there forever. We've got her for 20 or 30 more years, but she's not well regarded, and the majority just let the world know it.
Bill, as an aside, before I ask you about denaturalization, as a law professor, do you find that the students in your law school are radicalized when they get there or radicalized before they get there?
Well, I teach a course that has nothing to do with politics or social justice or anything like that. My students, I think, are pretty straight down the middle. And I think I'm fortunate. I'm at a law school that is not Columbia Law School. It's not Harvard Law School. It's not as radicalized. So I don't think the students, at least my students, become radicalized in law school. But there are certainly your social justice warriors who arrive that way. So I would say it's more a problem of how they are when they arrive and their world outlook that they've been taught in high school, maybe even K through 12 and college. They have a certain world outlook that I don't necessarily agree with. And that's, I think, more of a problem as opposed to what takes place in the law school, turning them into some sort of radicals. So that's my personal observation. But I think in general, law schools do push students towards becoming more left leaning.
All right, let's talk about something near and dear to my heart, and from what I understand, near and dear to yours, denaturalization. This is not something that's been tossed around a lot. The GOP's been real shy about things like that and wanting to kind of play nice, but the DOJ indicates they're going to start looking at it. Explain what it is, why, where are we going from here?
Sure. Well, if you have been naturalized as a citizen, so you're not, born here, and you go through the immigration process and the naturalization process, if at any point along that line you make material misrepresentations, you forget to disclose, not forget, you don't disclose things, you intentionally don't disclose things, or you lie on your applications, the government can move to rescind your naturalization, to strip you of your citizenship. And I covered at my website about a decade ago a very famous case involving a Palestinian terrorist named Razmia Odeh. And she came to the United States. She lied on her visa application about her terrorist connections. She lied on her naturalization application about it. She denied having any connections, but she did. And many years later, I think it was 15 years later, the FBI picked up on it and they filed criminal charges against her to strip her of her citizenship. And that is what eventually happened. She lost the first trial, she got a retrial, and right before the second trial, she consented to leave the country and she was stripped of her citizenship. So if there is a person here who lied on their immigration papers and their naturalization papers, for example, maybe they misrepresented their family connections, maybe they committed marriage fraud to become a citizen. And I don't, I'm not talking about anybody in particular, but there have been allegations against a congresswoman about that. If it is substantiated, if somebody lied to get into the United States and get citizenship, the government absolutely has a mechanism to strip them of that. And the Department of Justice, again, I don't know if they have a particular person in mind, but the Department of Justice has said they're going to start looking into that for people who have obtained citizenship and to challenge it. So it absolutely is a procedure. It has been used in the past and it can be used in the present.
I just want to make sure I'm being crystal clear with everybody that the professor was not discussing Ilhan Omar, who lied and married her brother to get into the country. He never mentioned that name at all. I just want to make sure he never mentioned Ilhan Omar. Thank you so much, Professor. I appreciate you. I would thank you for coming to my YouTube channel, but I know how brilliant it is, and I know you love it here. So subscribe and watch. We're going to start really ramping things up and putting some funny stuff, some interesting stuff out there, some collaborations. Either way, my YouTube channel is officially the place to be. So stick around.